Self-determination is a fundamental right and need. It promotes growth and well-being toward human potential through having basic psychological needs met, including autonomy, competence, and relatedness. Self-determination is being able to make your own decisions based off of your own personal goals. Self-determination is the right to choose your own health-related behaviors, which may differ from the recommendation of healthcare professionals. The Patient Self-Determination Act that was implemented in 1991 requires those that receive Medicare and Medicaid reimbursement to uphold the rights of people, including informing them about advanced care documents, being asked about admission and enrollment in advanced care, and being provided with information about their rights to complete an advanced care document. It also talks about how the community is to be educated about advanced care planning. There have been many acts, laws, and statutes that have been passed in order to protect the rights of mental health patients. The box on 3.1 indicates the Bill of Rights for persons receiving mental health services. Those include the right to treatment, the right to refuse treatment, the right for humane treatment, confidentiality of records, and accessing their own records, to be informed of their plan of care, to assert grievances, etc. It's important to note that even though an individual is receiving mental health services, they are not deemed incompetent. Competency is a legal determination. It's the degree to which a patient can understand and appreciate the information given during the consent process. It refers to a patient's cognitive ability to process the information at a specific time. This is different than rationality. Rationality is a characteristic of a patient's decision, not of the patient's ability to make a decision. When looking at the table on 3.1, it identifies ways to distinguish how an individual is considered competent. They can repeat what they hear. They should be able to paraphrase an understanding of the treatment, discuss the disorder and the need for treatment, outcomes, and they should be able to logically reason their choice of treatment. Informed consent is a legal procedure to ensure the patient knows the benefits and costs of treatment. To provide informed consent for care, the patient must be given adequate information to base their decisions and actively participate. A patient must be competent to give consent, but the individual's decision-making ability is often compromised by their mental illness, which does pose a dilemma. Most institutions have policies that outline the nursing responsibilities within the informed consent process. Individuals have the right to be treated in the least restrictive environment, which means they cannot be restricted to an institution when they can be successfully treated in the community instead. Determining the least restrictive environment for individuals with mental illness continues to be a difficult decision for mental health professionals. Individuals admitted under voluntary status means they may leave at any time, including leaving AMA. A patient may also be admitted under an involuntary admission or an involuntary commitment. This could be initiated at the time that they had been admitted to the facility or during a voluntary admission. There are legal provisions for people to be involuntarily committed to outpatient mental health facilities through state civil laws. Because involuntary commitment is a prerogative of the state agency, each state has their own commitment statutes. However, there are 3 common elements. 1, mentally disordered, 2, dangerousness to self or others, or 3, unable to provide for basic needs, i.e. considered gravely disabled. Patients who are involuntarily committed have the right to receive treatment, but they may also have the right to refuse it. There are differences based off of each state mandates. For the state of Missouri, patients are hospitalized on an involuntary basis for up to 96 hours. At the end of that time, the mental health provider has a decision to either continue the involuntary commitment process or allow the individual to either sign in voluntarily to receive treatment or to be discharged. The difference between privacy and confidentiality is important. Privacy refers to the part of the individual's personal life that's not governed by laws and the government, and confidentiality refers to the ethical duty of non-disclosure. While patients do retain the right to confidentiality, it is legally acceptable to breach that confidentiality, which is the release of that patient information without their consent for certain situations such as a duty to warn. HIPAA is the Health Insurance Portability and Accountability Act instituted in 1996 that protects several areas of healthcare, including privacy and confidentiality. In talking further about duty to warn and confidentiality, there are certain times when healthcare providers are legally obligated to breach an individual's confidentiality when there is a judgment that a person may harm or is about to harm someone else. Professionals are mandated by law to report it to the authorities. There are several different torts, intentional and unintentional torts. A tort is a civil wrongdoing. Intentional torts include assault, battery, medical battery, and false imprisonment. Negligence and malpractice are considered unintentional torts. Negligence is a breach of duty of reasonable care for a patient whom the nurse is responsible for that then results in personal injury. Maintaining and documenting appropriate standard of care can help protect nurses from legal issues. Communication, including the patient in healthcare decisions, adhering to policies and procedures, seeking expert consultations, involving the family are just a few of the things nurses can do to help mitigate legal liabilities.